Domestic violence first degree in South Carolina is a felony that carries up to 10 years in prison if convicted. The statute covers several different situations that are required for an arrest, and we'll cover those today. Hi, my name's Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina, and today we're talking about domestic violence first degree charges in this state. To establish domestic violence in the first degree, the prosecutor must show the basic elements of domestic violence and an additional aggravating factor. The aggravating factors are: there is great bodily injury to a household member, or your actions could result in great bodily injury to a household member. You commit a domestic violence second degree, which is a misdemeanor, but there is an order of protection against you at the time of the offense. You have 2 or more prior convictions, not arrests, for domestic violence within 10 years of the current offense. A firearm was used in any manner while committing domestic violence. While committing domestic violence second degree, one of the following occurs: a minor is present, the victim is pregnant, the offense was committed during a robbery, burglary, or theft, or you impede the victim's breathing or airflow. You stop a person from using a phone to call for police or for medical help. As you can see, the domestic violence first degree law is broad and covers a number of different situations. There are 2 common situations when you're talking about domestic violence in the first degree, and that is either the great bodily injury type or the domestic violence second degree with the aggravating factors. When reviewing the great bodily injury factors, the injury required is one that causes a substantial risk of death or permanent disfigurement or impairment of a bodily organ. This would require the state to show medical records of the injury or injuries to establish there was a substantial risk of death or impairment to a bodily organ. The more common cases that I often see have to do with stopping a person from using a phone call to call police. That's because it is often not just the alleged victim's phone that was broken or blocked from use. A lot of cases arise from situations where a spouse or a girlfriend see text messages or social media messages on their partner's phone. They then take that phone and lock themselves in a room, or there is a struggle over that phone, which then leads to the partner's phone being taken or destroyed. What's important in these types of cases is to show that the defendant's phone was initially destroyed or taken from them. Police will often not photograph the defendant's damaged phone or document that it even occurred. Sometimes it'll be visible on the body camera footage if police were wearing them at the time, or the alleged victim may describe that initial struggle on the body camera. Other times, you will need to show your attorney the phone. This can be vital in mounting a defense in your case, so it's important that you talk to your attorney about what happened before the police arrived on scene. If you're being charged with domestic violence in the first degree and want to discuss your options, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.